Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 183. I assume you'll all be delighted to hear this podcast has nothing to do with coronavirus or the furlough scheme. Instead, having finally managed to carve out a bit of space, we're going to look at three recent cases of general importance for employers. We've got one case dealing with the importance of getting a confidentiality clause in your settlement agreements right, one on disability discrimination and the potential remedies capable of being awarded by a tribunal, and one which, well, I think it's the closest we're going to come to the coronavirus story because it's to do with redundancy procedures. And sadly, I think the case is that we're going to get quite a lot of attention for this case because there are going to be quite a lot of redundancies waiting in the wings. And this case, I think, is going to get a bit of a mention. Please don't forget the podcast's available via iTunes, on the Mayer Brown website, YouTube, the Twitter feed, Nicholas ROBER11, and we put out links to the cases on Twitter, and we're Spotify, Google Play, Yahoo, all good booksellers, etc., etc. So, first up, Duchy Farm Kennels Limited and Graham William Steeles. It's a High Court decision on appeal from the Birmingham County Court, and the question in brief is, what happens if a claimant agrees that in a settlement that the settlement sum is confidential, and they then go and break that confidentiality, break the confidentiality clause? Can the employer stop paying them? Well, here, the claimant, Mr. Steeles, brought a number of claims in the Employment Tribunal, which was settled by way of an ACAS Cot 3 agreement. And the Cot 3 agreement seems to have been relatively standard. It only had 13 clauses in it. In one of them, the employer agreed to pay the ex-employee in instalments of over 47 weeks of the sum, in total, £15,500. The claimant, of course, promised in turn to set all his claims, apart from the usual exceptions for personal injury and accrued pension claims and so on. Clause 8 of the Cot 3 was a warranty that he'd not disclosed any details relating to the settlement before it was entered into. Clause 9 was a confidentiality clause, and I'm going to come back and read that. And Clause 10 was the standard non-disparagement clause. Clause 9 said in full, the parties will treat the fact of and the terms of this agreement as strictly confidential, and the parties will not disclose them to any other person or entity, save as set out in this clause or as may be required by law or any regulatory authority or professional advisers, subject to them maintaining the same level of confidentiality. Unquote. Well, obviously, given that we have this case at all, I think you can work out that the claimant did, in fact, speak to someone about the settlement. What happened was after the employers had paid just less than £3,000 to the claimant, the employer stopped paying, arguing the claimant had repudiated the agreement by breaking the confidentiality clause. Although the claimant denied this, the judge in the county court found as a fact that the claimant had disclosed the terms of the agreement to a former employee who had told at least one other person, and as a result, it made its way back up to the managing director of the employer, by which time I think 5 people were aware of the terms of the settlement. The employee sued for the outstanding money. The employer stopped paying, the employee sues for the outstanding money. The employer counterclaims for a declaration there was no obligation to make the payment because there had been a breach of the confidentiality clause. By the time the case gets to the High Court on appeal from the county court, the employer was asserting, first of all, that the relevant provision, Clause 9, the confidentiality provision, was a condition of the agreement. Alternatively, if it was one step down from being a condition, it was an intermediate category of term and a nominate term, and then it was capable of being reviewed as a repudiatory breach of contract by the claimant if, viewed objectively, the claimant's behaviour indicated an intention no longer to be bound by the terms of the settlement. In support of its position, the employer pointed out that although the settlement agreement was only 13 clauses long, 3 of them dealt with confidentiality. It accepted that Clause 9 itself did not say that it was a condition, but it did point out, for example, that it said it was strictly confidential, and the employer would otherwise be left without a remedy for a clause which made business sense to include in the settlement agreement to avoid the risk of copycat claims. Well, the High Court started by pointing out that the employee was only said to be in breach of Clause 9. There was no evidence that there had been breaches of, say, the non-disparagement clause, or that he breached confidentiality before the settlement agreement was entered into, Clause 8. Secondly, the High Court agreed with the analysis by the County Court judge to the effect that there were effectively three different categories of contractual term. Either the term was a condition, or it was a warranty, or it was an innominate term. If it was a condition, then a breach of that would entitle the innocent party to bring the contract to an end. If it was a warranty, then the only remedy for that would be for damages, and if it was an intermediate or innominate term, a breach might amount to repudiatory breach, but that would depend on the circumstances and nature of the breach. Here, the employer was arguing on appeal, first, that the relevant term was a condition, and second, that if it was one down from that, an innominate term, then the breach was such as to amount to a repudiatory breach. Like the County Court, the High Court placed emphasis on the fact that Clause 9 was not expressly described as a condition. It was, in the opinion of the High Court, merely ancillary to the main part of the contract. Confidentiality was not at the core of the agreement. The core of the agreement was the payment by the employer to the ex-employee, and the ex-employee giving up his claims against the employer. Now, the High Court did acknowledge that it would be possible for the parties to state expressly that the term was a condition, but since they had not done so, it was necessary to go through a process of analysis to work out whether, despite that, it was still a condition. Well, the High Court viewed this matter as being a fairly standard employment dispute with no significant commercial risk from breach of the confidentiality clause for the employer. They felt at most the risk that others would bring copycat claims. There was no reason for the parties to be significantly concerned about this risk, they said. The court pointed out the settlement was not for a large sum of money, and indeed there was some evidence that those who had learnt about the actual money paid through the claimant's breach were surprised at how low the sum actually was. From the point of view of the court, this was a generic clause, and it did not indicate to the court that confidentiality was of paramount or major importance to the parties. Now, part of what influenced the court was that this clause was not drafted in a way which reflected the reality of the situation. By this I mean there was no exclusion, as you will usually see, from the confidentiality clause to enable the individual to tell his or her partner or immediate family about the settlement, subject to those individuals maintaining confidentiality in their turn. The court, rightly I think, pointed out that it should hardly be said to be a breach if you tell your partner that you've settled the case and what you settled it for. But on the employer's argument, that telling his wife or his partner would have entitled the employer to forfeit any further payments. That was obviously going to be a tough sell. It was also pointed out that the confidentiality clause applied equally to both parties. Well, you and I, of course, know that that's for tax reasons. So there is consideration within the clause itself for the confidentiality obligation, and that's to ward off the possible argument by HMRC that the confidentiality clause is a type of restricted covenant, and so part of any settlement sum must be charged to tax because it's the payment for any restrictive covenant. Well, since the same clause applied to both employer and employee here, and the employee had zero interest in the confidentiality, it further showed, in the court's view, that this was an innominate term rather than a condition. So, having thus disposed of the first argument, the employer then went on to lose on the second argument. The court concluded that there was never likely to be any commercial embarrassment or commercial problems for the respondent arising out of the employee's breach. They did say, and I'm not entirely sure about this, that to the extent that copycat claims arose, well, that could be an action in damages. I'm not sure about that, because how would you ever know that a copycat claim had arisen just because of the settlement? A copycat claim would arise because someone thought they had a claim and was more likely to bring it. So, anyway, well, I think most people's immediate response to this is going to be to say that the employee was pretty lucky. By and large, employers hate news about settlements getting out. Rather than it being a copycat claim, and this is the way I think the employer had put it, but in my experience, rather than it being the risk of a copycat claim, I think employers are going to be far more concerned about employees claimants holding out for more money and being prepared to pursue negotiations more robustly with the employer when the litigation's underway, or indeed before litigation's underway, because they know the employer has paid off someone previously. Suspecting that a case has gone away because it's been paid off and knowing the terms on which it is paid off are two very different things, and one will give an employee or an employee advisor a lot more confidence in pushing arguments than the other. Obviously, the automatic reaction is going to be to ensure that settlement agreements state specifically that the breach of confidentiality is a condition. But even if this is included, I think an employer should be careful to explain if it is forfeiting future payments or seeking to recover payments that have already been made, why the confidentiality obligation is not simply boilerplate, but that it's a key part of the employer's willingness to enter into the arrangements. Additionally, if employers would want to be able to forfeit payments or reclaim payments made, then I think it would be prudent to go back and look at your draft settlement templates to make sure that the confidentiality clauses, and indeed any other important clauses, are specifically described as conditions. So that's Duchy Farm Kennels Limited and Steeles. Next up, Gwynedd Council and Barrett and others. This is an interesting and quite complicated case on redundancy procedures. As I mentioned at the start of the podcast, I think it's going to get quite a lot of attention because the most interesting part, I think, is the distinction it emphasises between redundancies involving appointments to new roles and redundancies involving reduction of headcount within existing roles. But let me explain. Claimants were all teachers working at a school in Wales, whose name I will not attempt to pronounce, but which is helpfully referred to in the judgment as School 1, from which I deduce that the president of the AT, who decided this appeal, was possibly equally cautious about having to read out the name of the school more than absolutely necessary. Anyway, what happened was that there was a reorganisation of primary and secondary education in that part of Wales, and that resulted in the permanent closure of School 1 and 9 other primary schools in the area. There was then a new school system set up, which included School 2, and, broadly speaking, that takes over the schools and the premises at which School 1 had been located. The claimants were teachers at School 1, as I say. When School 1 was to be closed, they were told about this. They applied for positions at School 2, but were unsuccessful, and as a result were paid redundancy. They were given no opportunity to make representations on the redundancy situation, or the process, or alternatives. There was no right of appeal against the decision to dismiss. Now, part of the complexity in this decision arises from the fact that the parties, at an early stage, agreed facts which were to be applicable to the dispute, including an agreement that there was a redundancy situation. The EAT acknowledged the parties were really trying to be helpful, but reading between the lines, it seems as if some of the facts agreed were not really as clear-cut in reality as the parties may have thought. Anyway, when challenged about the lack of appeal, because the employees were claiming unfair dismissal, and this was front and centre, when challenged about the lack of appeal, the employer in charge of School 1 apologised, acknowledged there'd been no appeal, but said there had been no disadvantage caused because the dismissals were caused by the closure of School 1, and that was not something that an appeal panel could have changed. Well, at the employment tribunal stage, the employer came off pretty badly on this point. The tribunal was really strong in the assertion by the employer that the right of appeal would have been valueless in this case. They described it as ill-conceived and emphatically wrong. The tribunal said the appeal was a fundamental part of a dismissal process. It allows the employer another opportunity to look at its dismissal and offers employees the opportunity to show the employer's reason for dismissing them could not be treated as reasonable. Quote, "An appeal is ingrained in principles and natural justice, and though I do not say that the absence of an appeal would render every dismissal unfair, I do determine that it requires truly exceptional circumstances to refuse an employee the right to appeal against their dismissal. Such exceptional circumstances do not exist in this case." Unquote. Well, the employer also tried to argue that if there had been a breach, then there should be 100% Polkey deduction because it would have made no difference to the outcome. The tribunal rejected that, saying it was not appropriate to make any Polkey reduction because the procedure adopted was so unfair it would be inappropriate to speculate on what might have happened. Well, the employees win their case, the employer appeals, it goes up to the AT. The AT start by concluding that just because there was a redundancy situation, it did not mean that dismissal was inevitable. Many of the staff at School 1 were never dismissed on the closure of School 1. They were offered employment at School 2 and so moved across. Secondly, the respondents, the employer, tried to make a lot of the tribunal's emphatic statement about the importance of appeal, and in particular pointed to the fact the tribunal had referred to the need for, quote, quote-unquote, truly exceptional circumstances before a dismissal would be fair without an appeal process being part of that. Now, one of the benefits about having done employment law for as long as I have is that I remember back in the mid-80s, when I started doing employment work, it was generally understood that employers did not have to do an appeal process for a redundancy dismissal. The consultation process that one went through before getting to dismissal was the equivalent safeguard. Indeed, I think I recollect this, a similar approach was taken in relation to sick employees whom you expected to consult before reaching any decision to dismiss. Obviously, I think we've increasingly seen a move away from that. And indeed, at one point, I think the late and unlamented statutory disciplinary and grievance procedures potentially accelerated the development of the right to an appeal, even in the case of redundancy. And that is, I think, where most employers would accept we are now. Here, the EAT looked carefully at what the tribunal had said and concluded that the Employment Tribunal was talking about fairness generally rather than a point of principle, i.e. there would have to be truly exceptional circumstances, otherwise the dismissal would automatically be unfair. The EAT was clear that it did not suggest there had to be an appeal process unless there were truly exceptional circumstances. That was not the EAT's view. They rightly, of course, go back to, well, the overall test is fairness under Section 98(4) of the 1996 Act. And here they decided the Employment Tribunal was applying a fairness test and whether the employer's approach fell within the bands of reasonable responses. The tribunal entitled to find it did not, and that was an end of that ground of the appeal. However, it's the final part of the decision that I think has the most interesting part in it. The employer also challenged the tribunal's criticism of the recruitment procedures for School 2 jobs. Bear in mind they're teaching jobs and seem to have been very similar to the teaching jobs done by the unsuccessful teachers from School 1. The employer's argument was the tribunal had referred to the guidance in Williams and Compare Maxim, which is a 1982 case, and which sets out standards expected of an employer in a redundancy selection case, i.e. criteria should be agreed where possible. Selection criteria should not depend solely upon the opinion of the person making the selection, but on things that can be objectively checked, such as length of service, efficiency in the job, experience, etc. Selection must be made fairly in accordance with those criteria, according to Compare Maxim, and employer obviously has to consider the possibility of alternative employment. Well, we've known for some time that in some cases employers hold interviews for roles as an alternative to doing the redundancy selection marking process. So in Morgan and Welsh Rugby Union, the EAT drew a distinction between a case where the employer was selecting out of a pool of existing employees and reducing headcount, where the Williams and Compare Maximum would be approach would be applied, and instead, on the other hand, one where two roles are being merged into a new role and something, quote, forward-looking, unquote, would be required, which would look at an assessment of the ability of individuals to perform in the new role, hence it being forward-looking. That would be something much more like an interview process. Now here, the employer went through an interview process without any appeal or consultation. The EAT said the tribunal was entitled to find this as unfair in the circumstances because there was no opportunity given to the claimant to challenge the dismissals or to be consulted about the manner in which the redundancy exercise would be carried out. The tribunal found that the claimants were applying for either identical jobs to their existing ones or substantially similar jobs, and on that basis the EAT said, quote, where recruitment is to the same or substantially the same role as one which the employee was doing, then the exercise may not involve forward-looking criteria at all, but something closer to selection from within a pool, unquote, stop. So the reason I wanted to mention this is that we've seen cases where employers have sought to sidestep marking against objective criteria by requiring people to apply for their own roles or be made redundant. Employers often think that gives them considerably more flexibility to engineer the quote-unquote right outcome. Well, I think this case puts the brakes on that. It makes it clear that unless you can justify the need to have forward-looking criteria, because the new job is, in my terms, markedly different from the existing job, then the standard selection process, selection criteria, marking, etc., will apply, unless, of course, in your collective consultation, you manage to agree something different with the union or the employee representatives. The other problem, of course, with making people redundant and expecting them to apply for their jobs is you are effectively giving people the right to take voluntary redundancy. If individuals do not apply for their jobs, or they are made to attend interviews and deliberately mess up the interview, there's very little the employer can do about it. That's another reason why I would always be very cautious about going through an interview process unless there was a good reason to say that the future ability to do the job was the single most important factor and the employer was comfortable with accepting voluntary redundancies. So that's Gwynedd Council, the Gwynedd Council case, and Barrett and others. And third and finally, Mrs. Hill and Lloyds Bank. This is an appeal by Lloyds Bank, the 8-year case again, against a decision by the Employment Tribunal, and there was a counter-appeal by the employee against the decision by the tribunal to revoke a recommendation which it had initially made in favour of the claimant and then thought better of it. I'm going to say up front, I have a real problem with this case. I think it takes us into some quite dangerous territory, and I think it could mean we're going to see quite a lot of creative uses of the recommendations procedures in the light of this, which I don't think are truly justified. So, underlying facts. The claimant has worked for the employer for somewhere up to something like 30 years. She continues to work for them. It was alleged by her that she'd been bullied by her manager, Mrs. M, and Mrs. M's manager, Mr. B. The tribunal was not asked to make findings of fact in relation to that, but the claimant made clear that she didn't want to work for Mrs. M or Mr. B in any circumstances ever again, and, we are told, those two individuals likewise made clear they never wanted to work with the claimant again. Good for everyone. Well, claimant worked in the Bristol office, the two managers, one of them worked in Glasgow and one of them worked in London. Now, the claimant, critically, asserts that she is disabled and that she's suffering adversely because she is concerned that in the future she might have to work with one or both of the individuals again. Her uncontested evidence was that this caused her additional medical issues, anxiety, dread, etc. The union, representing the claimant, requested an assurance from the employer that she would not be put under the control of the two people, which morphed into she wouldn't be required to work with or under the management of Mrs. M or Mr. B ever again, without limit. Well, the employer responded, as I imagine we would all respond, whilst it wouldn't wish to put anyone in a position which would be detrimental to her personal health and well-being, it could not offer an absolute guarantee this would never happen in the future. It was simply unknowable, and they would not offer a guarantee to offer redundancy or severance as an alternative, given that her role would not be redundant if she elected to leave simply by virtue of having to work for or under the control of either Mrs. M or Mr. B. The Employment Tribunal decision found against the bank on the claim of disability discrimination. In particular, the tribunal decided that there was a provision, criterion or practice applied to the claimant when she was denied the undertaking that she requested. Now, the tribunal accepted that if this had just been a one-off decision and solely in relation to the dealings with Mrs. Hill, then it wouldn't have been a provision, criterion or practice. But the bank's witnesses had said in terms that the bank's policy was not to give binding undertakings, but to give words of comfort, to use best endeavours or make best efforts, etc. In other words, there clearly was a PCP, i.e. we will not give you a guarantee, we will give you softer wording, and that was applied to her. The question was whether that had a detrimental effect, a discriminatory effect on her, and I'll come back to that point. There was also the issue of the undertaking that was being sought by the claimant. As the respondent pointed out, the claimant wanted an adjustment now for the risk of a disadvantage in the future, and so there was no substantial detriment shown now. But given that the claimant's medical evidence, which she gave herself, was unchallenged, the claimant was able to show, relatively easily, that she was placed at a significant disadvantage in health terms as a result of the failure to offer the undertaking, because she worried more about having to work with the individuals. The tribunal, somehow, managed to come to the conclusion that the causation of the claimant's health was that she might be, the claimant's ill health, was that she might be later required to work with Mrs. M or Mr. B, and that others who were not disabled, but who had been similarly allegedly bullied, would not have suffered to the same extent. It's quite remarkable, but anyway, the tribunal comes to that conclusion. And I suspect there's some factual evidence that doesn't appear in the EAT's decision. But this finding seems to be very odd. But anyway, there's no explanation in the decision as to why a victim of bullying who wasn't disabled would have not felt precisely as anxious as the claimant did about the possibility of encountering the alleged bullies again. The bank further argued that it was unreasonable to require them to undertake to make a substantial redundancy or severance payment at some point in the future. But if the employee was not in fact redundant at that point, and the whole point of the reasonable adjustment, they said, is to keep the employee in work and not make provision for her to leave work. I think the second point, the adjustment couldn't be the adjustment, meaning you give the guarantee. I think that, understandably, the tribunal knocked back the employer's argument that this was not about keeping her in work. The point of the adjustment, you will give the guarantee, would be to allow her to carry on working in circumstances where she might not otherwise be able to carry on working because of the impact on her health, because of her worries about working with Mrs. M or Mr. B ever again. I'll come back to that point. The EAT said there was nothing wrong in requiring an employer to give an undertaking to provide a disabled employee with certain benefits if in future certain circumstances arose. That, as a matter of norm, was a permissible ambit for a tribunal recommendation to require. The Employment Tribunal set aside its own original recommendation, which, it has to be said, was rather vague, but the EAT was asked to consider whether a recommendation could be made by the claimant, i.e., and the claimant wanted a guarantee that the employer would write to her promising that she would never be required to work for or under the control of Mrs. M or Mr. B, failing which she would be given a redundancy severance payment. Well, not surprisingly, the employer locks horns on this, and so the EAT starts by looking at section 124 of the Equality Act 2010. One of the employer's objections was that under section 124 (7) compensation is payable if the respondent fails to comply with the recommendation. Here, amongst other things, the respondent's argument was that it would be inappropriate or unjust if, having given the undertaking, it turned out the individual could not be kept away from Mrs. M or Mr. B, and they then had to pay compensation. So the employer was worried it was going to be liable for compensation for breach of its undertakings. The EAT said, no, that's not right. In order to comply with section 124, all that is necessary for the employer in this situation would be to give the undertaking. The recommendation was give the undertaking. If subsequently it turned out that the undertaking was not being complied with, that wouldn't go back to the Employment Tribunal under section 124(7). It might give rise to a constructive dismissal claim, it might give rise to other complaints, but it wouldn't get additional compensation under section 124. The EAT further said there's nothing wrong with a recommendation for an undertaking that would have potential for financial implications for the claimant. Here, the financial undertaking was to reinforce the basic undertaking that she'd not be required to work with Mrs. M or Mr. B again on principle. There was no problem with the recommendation that required steps to be taken immediately and then putting them in place indefinitely. Give the undertaking now and it stays in place indefinitely. The EAT said ultimately they saw no reason why the Employment Tribunal should not make a recommendation on the lines proposed. The issue itself, however, had to be remitted back to the Tribunal for it to consider the recommendation of whether to make that. My problem with this case, well, it's where this takes us. The employee is to get an undertaking from her employer that she will not work for or under the control of either of two named individuals. Well, what happens if the claimant applies for a job in an area under the control of, say, Mr. B? Mr. B's rights, bearing in mind he's not been found guilty of bullying, are they subordinated to hers? I.e., the employer can't consider him for promotion, which would put him into a controlling position over the claimant? What is a controlling position? How many ranks of management between them would cease to count as controlling? But then the alternative, if that does happen and the company has to pay a redundancy payment, is, if anything, even odder. My question is this: why a redundancy payment? The employee isn't redundant in these circumstances. Why is it appropriate or logical to pay a disabled person a sum of money calculated by reference to a completely unrelated set of circumstances? Why is she not, for example, entitled to 12 months' salary and bonus, or the average salary for an employee at the employer, or the chief executive's salary? Why is she not entitled to 2 times redundancy on the grounds that as a disabled employee she will find it very difficult to obtain alternative employment? All this, it just seems to me that we're fixing one problem by throwing a sum of money at it that's nothing to do with the problem. Now, I don't know whether this case is going to go further or whether the employer will take its chances back at the Employment Tribunal, which after all revoked the original recommendation. There is clearly a lot of evidence and material in this that didn't make its way into the EAT decision. But I certainly hope the employer is going to take it further, because I think this is going to open floodgates. An employee who claims they're being bullied is going to say, in future, I'm here, I'm still working, I've suffered bullying, and I want you, the employer, to guarantee it'll never happen again, and if you can't, I want you to pay me a large sum of money. And that's going to be the recommendation that we're going to see time after time after time in employment tribunal cases. I'd be interested to see what others think of this. And it may be, who knows, maybe I'm overreacting, maybe lockdown's got to me. But I do think this is a very odd and worrying case, and it gives rise to all sorts of problems for employers if claims are brought by ongoing employees for discrimination, disability discrimination, but other forms of discrimination. And in any event, it seems bizarre to have a remedy for an apparent, hypothetical, as yet unknowable wrong, which is calculated in relation to a completely different set of circumstances. Anyway, thank you all for listening. I can confirm that at least 3 cans of Barnard Castle eye test were consumed in the making of this podcast, but none for the purposes of my review of the last case. Stay safe, everyone. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.